Okay, so our topic is called Hot Topics in Immigration. However, if you've been paying attention to the news at all, you would see that that is a wide array of everything that's going on right now. So we decided to focus it a little bit more on some of the things that we think are going to pop up, which is more enforcement and compliance. So everyone has to have an I-9. There's probably someone in your corporation who's in charge of I-9 compliance. And luckily, there is a new form that just came out. You should have been using that as of September 18th, so Monday, the new form. So I'm going to go over with you a little bit about some tips on that new form to make sure that you don't have any paper violations, make sure you don't have any fines, and in case you do, I have our expert on white-collar crime, Holly, who will walk you through the process of what happens if ICE comes knocking on your door or another government agency for not complying with our immigration laws. So along with that new I-9 form, we also have the new employer handbook, which is the M274. I'm not going to dive too much into that. It's a huge document and pretty self-explanatory. Some other things that came up on the compliance level that actually we didn't put in our PowerPoint. Again, it's hard to keep track of everything that's going on right now, but there's a big push right now with H-1Bs. H-1Bs are temporary work visas, and they're for skilled, highly skilled workers. Well, during this time, there's been an executive order specifically on employment-based immigration, pretty much attacking the integrity of the H-1B program, and in my opinion, it's quite frivolous. There's only 85,000 H-1Bs, new H-1Bs approved per year. They're looking at it. They had some bad press, if anyone's heard of that Disney case where, and I'll get into it a little bit, where they're focusing on IT businesses and whether you're taking out the US worker to benefit an immigrant and potentially paying them lower wages. In Iowa, they had a vote in the legislative session whether they were going to do the E-Verify mandate. That did not pass. So, but keep in mind, you may be working for a corporation that has E-Verify in other states, and you'll want to make sure that you're in compliance there. Again, the focus right now is on fraud. They're looking for it everywhere. We expect to have an increase of site visits. These aren't necessarily raids where they're coming and swooping in and taking all of your employees, but this is more so I-9 audits, desk audits, making sure that you haven't committed any technical violation with the form. We do expect, we've been hearing that they said there'll be a 20% increase. This is triple the amount that we had last year, and kind of where we were at the beginning of the Obama administration, but that really tapered off. Lastly, the Department of Justice came out with new enforcement. It used to be, let's not discriminate against the immigrant worker. Now they're looking at it from the other side, don't discriminate against the US worker and put the immigrant first. They also had new executive orders that came out. There were, in addition to the one I referenced on H-1B workers, they had an executive order on interior enforcement and exterior border enforcement, and the lovely travel ban. So right now, the travel ban is sort of in place. It's where if you're from one of those 6 countries that they named, you'll have some higher scrutiny coming in. They're still able to search your laptop. You have to be coming in, and it has to relate to either a family trip or a business trip, and they have their own interpretation on that. But actually, the Supreme Court will be taking a look at what they're going to do with that in October, actually. So there have been a lot of changes. What does this mean for all of us? Well, as you're all lawyers, you know that laws don't change overnight. We do have to have a budget approved, and this has to be passed by Congress. We have been seeing that they've been doing some things out of order or interpreting things the way we haven't seen it happen before. On the H-1B context, if any of you practice immigration law right now, you're probably getting a flood of RFEs, requests for evidence right now, where a job that used to be a computer programmer, a software developer, was easily approved, no questions asked. Now they're asking us to go through and explain why it's a specialty occupation, how so, why we picked level 1 on the labor condition application, and they're really taking a look at these again, I guess it's within their right and they can, we just have to have more creative ways to go through this. So I discussed that we're going to talk about some I-9 compliance, a little bit on how to prepare and respond for an audit, and then Holly's going to talk about how we respond when law enforcement comes knocking. I mentioned the new I-9 form. Another thing that you can do is I-9s can be completed electronically. I understand that not every business will be able to have this happen, but actually when you complete it electronically, there's some checks and balances there. Now it'll pre-fill in for you if you check one box and it doesn't apply to the others. The other ones will self-populate where you can't, it'll say NA, not applicable, or just become a kind of a grayed-in box. So it's actually a nice feature. It helps you double-check your work and could actually prevent some additional fines, or any fines at all. So now I'm going to go through different pieces of the form, and in your packet you should actually have an I-9 at the very back of our materials. On the screen it's a little bit hard to see, but this is blown up. And I'm not going to cover everything about the I-9, but just different things we've been seeing where you might not be in compliance. These fines can add up, and if you don't do it right the first time, it can be pretty difficult to correct. So this first section, I-9 Section 1, this is what the employee completes. The very first thing that's important on this is the timing that you offer this I-9 to be completed. So you can't give it to them right when you send the offer. That would be a violation. You have to have offer and acceptance. So go back to your contracts rules, make sure you have offer and acceptance before you have your employee fill this out. But it also has to be completed on your first day, no later than the first day of employment. When the employee is filling out this section, you just have to make sure you don't know, what their address is. You don't know if their address is correct, but you have to make sure every box is completed. You're not going to be on the hook if they put East and they actually live on West Street. But you do have to make sure that all of the boxes are completed. There are 3 things that you don't have to complete on this box, and that is your email address, phone number, and if the employer uses E-Verify, the Social Security number. So now this next part, which is probably the most important for immigration compliance, this is where the employee says their immigration status. It can be that they're a United States citizen. These boxes are mutually exclusive, so you have to pick one of the boxes, 1 through 4. If you select 4, that's a really tricky box, right? Because that says that you're employed, that you have authorization to work until a specific date. Now that specific date, you need to make sure that your office is calendaring that somewhere so that your compliance legs go up, because if you get to that date and you have nothing to fill in there and that person is still working, that would be a knowing hire violation. And a knowing hire violation is a very serious violation. That means so the employer can get dinged on multiple ends and potentially face some criminal charges, because at that point you're employing someone who does not have authorization to work. This next box is something new that they put on there. It's Prepare and Translator certification. Again, if you do it online, it'll have both of the boxes, but this is just something that you do have to make sure you complete. Then we go to this section, I-9 Section 2. This hasn't really changed, but it's important. Lots of people forget to put in the employee name again. There's this box up there that says Citizen Immigration Status. And what that refers to, it's not asking you to put in United States citizen or lawful permanent resident. It wants you to go back on Section 1 and put in one of the numbers 1 through 4. So we've seen a lot of weird things come in that box. You will get a fine if you don't fill it out correctly. This documentation part of Section 2 hasn't really changed. Other than that, you can now you click on those and it has drop-down boxes and you can select one of those if you're doing it electronically. You'll see on a lot of these, at least on the PowerPoint, it has a question mark with a circle around it. If you click on that, that pops up with instructions on how to complete the I-9. If you aren't doing it electronically, a new rule is that you need to provide all of your employees with copies of those instructions. Now, the weird thing about the document is for the I-9, it can take more than one document to create what's called a document. So it could be your passport plus your I-94 document, your I-20 plus your I-94, and those all together create one document. This other box here that they added, they used to say put things in the margin, and now they have a place where you can put some notes in. So here's a good place where you can calendar, hey, this person can only work for a year, or this person has an automatic extension that comes with their work permit. And I think it's really important to write notes, not only so that if someone comes in to audit your I-9s, but let's say your HR person changes and someone needs to know what's going on, what happened with that employee, what they're looking at. This section, you'll have to call Holly if you fill it out wrong. This is the section where you certify under penalty of perjury, which is a felony, and so this isn't for the employee, this is for the designated person in the organization says, look, I have taken a look at these documents. They appear to be real to me. These look like they relate to the person who's standing in front of me. The documents appear to be authentic, not that they've been created in a garage somewhere. And that to the best of your, and I think this is the most important part of it, to the best of your knowledge, the employee is authorized to work. So even if all of the documents look like they add up, if you actually know this person doesn't have the ability to work, or if they came to you and said, hey, I'm not sure if these documents will work, don't sign that form. You as an individual will be on the hook for it. The company will be on the hook for any paper violations, but you as the individual will have to suffer the criminal charge. Section 3 is the re-verification section. This is where it relates to that section 4 box, or box 4 in section 1. This is, and again, make sure while you're doing this, it gets repetitive. You have to put the employee name on every single one, but that's because you might have multiple section 3s. Section 3 is for when that work card expires, you go back to them because you've calendared that date. Perhaps you let them know a week in advance, a month in advance, hey, this date's coming up, I need to make sure that you can still work, present me some sort of document, and we'll move on. And with that document, I forgot to mention, so when you're looking at these documents, you can make a business decision on whether you want to keep a copy of these documents or whether you're only going to look at them and verify. So if you keep a copy and you accidentally wrote the document number down, even though it was a valid document, if ICE comes in to do an audit and you have a wrong number in there and you have a corresponding document, that would be called a technical violation. And you can cure that technical violation within 10 days if you submit the proper documentation. If you don't keep a copy of the document or it's not a legible copy, you go back and you have nothing to prove, you can't work your way out of that fine. So on this re-verification section, you have to, here it says there's still only room for one document. If you're writing it, you'd have to squeeze in that sometimes it's 2 documents. If you're doing it electronically, it'll give you the prompts for it. But in here, this is where you put in that additional extension that they have. Perhaps it's an automatic extension on their work card. Perhaps they have renewed or gotten a different status because they married a United States citizen. So you would complete that box. This also talks about, if they have a new name, you don't always have to fill out a new section 3 if they get married and have a new name. But if they come to you and have a new work card and a new name, then that's where you can fill that in. I kind of touched on these compliance issues. So who do you I-9? You I-9 everyone that's an employee. And the employee that's definitely a question of fact. So lots of people, I reference on here ghost employees. So a ghost employee is, the person's not authorized to work, but you have them at your work site anyway, and you call them an independent contractor. Well, immigration might differ with you on who an independent contractor is, and so you really want to make sure that if they truly are an employee, you have an I-9 for them. I referenced joint employment. That's co-employment, like if you have a service agreement with another company, you want to make sure in your contract up front that you have referenced who's responsible for having that I-9. A lot of times it is that service company that would have the I-9, and make sure that they will comply with immigration and hand it over. Some other thing that comes up is remote hires. This comes up all the time in the IT world. Someone has to physically lay their eyes on those original documents. Now, your new employee can act as an agent and affirm that those are the original documents, but you have to have those original documents. Some other housekeeping things: if you're looking at a document, again, make sure that if it's in that list B of documents, you're not re-verifying that document. And also, a good rule of thumb is never request the same document. If they bring you an I-94 card, which is what gives them permission to enter into the United States and tells you how long they can stay here, make sure that you're also not requesting that I-94 again. Perhaps they switch to a different status and they have an I-797 that allows them a different period of time. As long as there's something that shows you the period of time, you can use that document. And you don't have to re-verify for green card holders. The last note I'm going to get into here is the automatic extensions. This just came out in January of this year. They added about 13 new categories for automatic extensions. And we've actually had some calls on this where people say, oh, this person, you know, their work card ends, I have to terminate them. Well, the employer has to go back and make sure that they've looked at that list and that it's not one of those employment cards or work authorization that you can re-verify. So if you've terminated someone when they actually had an automatic extension, you could get fined for discrimination as well as I-9 violations. And now I'll let Holly take over on what would happen if you don't comply with these.
Hi everyone, we're trying very hard to stay on time here so you get to your break right at 2:30. We don't want to eat into that break for you, so I'm going to move very, very quickly, but by all means, if anybody has questions in the meantime, just throw up your hand. So in getting prepared for site visit by any federal agents whatsoever, immigration agents, Homeland Security agents, just the FBI agent, you want to ask yourself, does your company have a policy or procedure in place for site visits? The first thing in that policy or procedure should be, the first thing we do is call the lawyer. Because the agents will a lot of times by telephone tell the lawyers why they are there. And we've actually had it be the case in the immigration context that the agents, we said to the agents, okay, hold on, we'll be there in 15 minutes. And the agents left and never appeared again. It was probably a once in a lifetime thing for that to happen, but hey, it happened and it might happen again. So we're going to take advantage of that if we can. You want to figure out in terms of your policy who speaks for the company, because it's scary when a group of agents walk into your business and they have a search warrant, and the first person they're going to walk up to is your receptionist. And they're going to say, hi, it's ICE. We have a search warrant here for your entire premises, and we need the computers of these 25 people, and we need these 50 bankers' boxes of documents, and we need them right now. You want to have your receptionist know which person at the company is responsible for that and who she should call immediately. And that's the most security that you can give the receptionist in that situation. Otherwise, she's left to her own devices. Who knows what's going to happen in terms of who she calls, or whether she just lets the agents right on in and no attorneys get called in the process. Do's and don'ts for employees and a list of know your rights for employees are things that you should put in your employee handbook. So, for example, after the agents show up with a search warrant and gather all their documents, the thing that they're going to want to do immediately is speak to any employees that they believe have knowledge of whatever criminal issue they're there to investigate. And all employees think, well, this is a federal agent, of course I have to cooperate. of course I'm going to sit in this conference room and speak to them and spill my guts to them for an hour and a half. And so part of the Know Your Rights part of your employee handbook should say, if the government visits, it's your choice to do one of three things. Number one, you're free to talk to the agents. Number two, you're free to decline to talk to the agents. And number three, you're free to talk to an attorney first and then decide what to do. The most important thing there from an employer perspective is do not tell the employee what to do, because that can be looked at as obstruction of justice by the government if you're telling your employees not to speak to the government. And we'll talk a little bit more later about obstruction of justice. What's hot now in terms of immigration criminal enforcement? I was at an immigration seminar earlier this spring in Phoenix, and we learned the latest hot topics in criminal enforcement in the immigration context are fraud and misuse of visas, permits, and other documents. And then, as Liz was going through with you, all sorts of Form I-9 issues. And those are prosecuted under the just generic false statement statute, making a false statement to the government, or the generic conspiracy to defraud the United States statute. What are the stages of a criminal investigation? First, something triggers the government's interest in your employer. Then the government starts gathering documents and reviewing documents. And at that stage, you may or may not know it. So, for example, if they issue a subpoena to your bank, there is a law that requires your bank to keep that confidential. The bank can't tell you, hey, we got a subpoena from the FBI to turn over all your banking records for the last 10 years. It could also be the case that you have a disgruntled employee that goes to the government in some capacity and takes a bunch of documents from your workplace and turns those over to the government. And so that employee is working with the government and feeding them documents. Then after reviewing documents, the government starts its informal interview process. So that's where I kind of harken back to make sure your employees know their rights, that they really don't have to speak to a government investigator just because he's an investigator or a police officer or something like that. Next, there will likely be a grand jury investigation. And a grand jury is sort of this secretive body of about 26 people that meet once a month. Here in Des Moines anyway, they meet once a month, and in Cedar Rapids as well. They have the power to issue subpoenas to get documents from anywhere, any employers, any banks, any place they want to get documents. And they also have the power to receive testimonial evidence. So they can send you a subpoena and say, come in and talk to us and testify before the grand jury on Monday at 10 o'clock, and generally you have to do that. Next, the prosecutor asks that grand jury to issue an indictment for the crime at issue. And the old saying goes that a grand jury would indict a ham sandwich, and I've found that to be mostly true. I've never heard of a case where the grand jury failed to indict a crime, though they're supposed to sort of have this air of objectivity. What they hear and what they see is mostly the criminal side of whatever issue is in front of them. Important to remember that these stages can overlap. They don't go in this neat row that I've explained them to you in, and it can take a very long time. So the statute of limitations for most federal crimes is 5 years, and I've had many investigations last longer than that. What happens in that scenario is the prosecutor asks you to sign what's called a tolling agreement, where you agree to toll the statute of limitations pending the government's results of their investigation. And it's in your interest to sign a tolling agreement so the government doesn't hurry up and make whatever charging decisions it would make as of that day without completing its full investigation. How do you know there's an investigation? First, you receive anything from a grand jury, and as I say, that's usually a subpoena for documents or a subpoena for testimony. There are interviews being conducted by, in the immigration context, ICE or Homeland Security. Also by the Department of Labor Wage and Hour Division. They have criminal authority over immigration-related topics. And then the Office of Federal Contract Compliance, if you are an employer that does business with the federal government. You also know there's an investigation if a search warrant is executed at your place of employment. If there's some sort of event that triggers the government interest in you, let's say there's some kind of accident at your workplace that causes injuries to a number of people. Next, sometimes the government just tells you, look, we're investigating this issue and we think your client committed this crime. Sometimes they'll tell you that from the very beginning. And lastly, believe it or not, sometimes you tell the government that a crime has occurred at your business. I have a case going now for an employer who discovered that their general manager had directed a number of employees underneath of him to commit a number of crimes. And so the board of directors decided on our advice that the best way to protect the entity, or to try to protect the entity, was to take what had happened to the U.S. Attorney's Office and self-report in an effort to just focus the crime on the general manager and not on the entity itself. Yet to be determined whether that worked. There are 3 categories of people involved in an investigation. You'll see the witness has a smiley face beside it. Everybody wants to only be a witness in a criminal investigation. What you don't want to be is a target. A target means you're typically going to get indicted or get charges brought against you. The middle category is a subject, and those are people for whom the government hasn't yet decided whether they are a witness or a target. So kind of the most unknown category. Next, I have Martha Stewart up here. We're going to start talking about obstruction of justice with Martha, because most people, or most lay people, I won't say you people since you're all lawyers, think that Martha was convicted of insider trading, and that's not the case. Martha was convicted, of course, of obstructing justice during her interviews with the government during her case. We white-collar criminal lawyers sort of look at the obstruction of justice charges as doctors look at the Hippocratic Oath. You know, doctors sort of think first do no harm, and we white-collar criminal defense lawyers think first don't let your client get themselves another charge in addition to the charges that are being investigated by letting them obstruct justice in any way along the way of the investigation. This is the obstruction of justice statute. I won't read it to you in the interest of time, but you can see how very, very broad it is. And you can easily see, this statute's in your materials, that telling an employee not to speak to the government in an interview could easily qualify as obstructing justice. This is the client response typically when a white-collar investigation gets started. They tell us, wait a minute, we need how many lawyers? And that's because targets and subjects must be separately represented. Their interests are divergent enough that they each need separate counsel. This applies to the company as well, so it needs its own counsel. But thankfully, witnesses can be jointly represented. I once represented 18 witnesses in total in a trial down in Florida, and so you can group as many witnesses together as you need to. Take care about using in-house counsel to represent anyone, and that's because the government takes this weird view during any white-collar proceedings that in-house counsel can't be objective enough to do a thorough investigation and to thoroughly take into account the risks involved for the company. They sort of view them as too tainted towards the company viewpoint. The company can, and sometimes it must, pay for counsel for officers, directors, and employees. It just depends on the company's bylaws. A lot of bylaws provide for that protection. Why do you perform a parallel investigation? So once we find out the government is performing a white-collar criminal investigation, then on the defense side, we want to mirror that investigation or beat the government at its job and its investigation. And so you do that because it provides a realistic evaluation of the company's exposure. You know, do we have a problem here or do we not? Second, you want to get in and present to the government what happened here before the government makes a charging decision. So the government will get very firmly rooted in its thoughts about the case. Once it makes a charging decision, you want to get in there before that happens. And second, you're preparing for trial. And the rationale there is that once an indictment is issued, you get a trial date very early in the case, usually within 3 months or so of your arraignment date, you're getting a trial date. And so you want to be ready in a hurry. When you're performing the parallel investigation, you want to start with the documents just like the government does, and then move on to your witnesses. Remember that time is of the essence, and remember to use outside counsel to do so. Again, because there's a chance that you're going to turn the results of this investigation over to the government in an effort to cooperate with the government on behalf of the company. And the government will think much more of your investigation if it's done by outside counsel than if it's done by inside counsel, because they view it as inside counsel has too much to gain or lose in this investigation to do a good objective job of the investigation. This is sort of what I was alluding at with possibly turning over the results of your investigation. Corporate cooperation with the government is often the key to avoiding an indictment against the company. Cooperation often means sharing the results of an internal investigation, including a waiver of all attorney-client privileges. And that can obviously pit the company and its officers or employees against each other. So in that case that I was just telling you about, where my client just decided to go to the U.S. Attorney's Office and self-report its crime, obviously that has pitted the company or the board of directors against this general manager from the get-go. And so there are people within the company that were beholden to that general manager that thought the company did him sort of a raw deal by doing that. So it presents a sticky wicket, that's for sure. The government came out with what's called the Yates Memo at the end of 2015. And the focus of that memo is on individual accountability for corporate wrongdoing. So really gone are the days when the corporation takes the hit, or the corporation alone takes the hit for corporate wrongdoing. The government really looks to individuals now that were involved as well. I sort of alluded to this earlier, that you want to make the case before the government makes a charging decision. You want to head off the prosecution or limit its scope. You know, maybe you can get them to charge under a statute that doesn't have a mandatory minimum fine or a mandatory minimum prison term. Maybe you can get them to only prosecute one person instead of 5 people. So you avoid undoing the government's commitment to its case. It's important to remember that you can't bargain civil versus criminal. Never can we walk into the U.S. Attorney's Office and say, oh, we'll pay a fine of $750,000 if you'll just make this criminal case go away. They cannot do that ever, and they'll be offended if you offer them that. And lastly, remember that credibility is your biggest asset. So you want to have attorneys that have good reputations with the prosecutor's office and with the judges representing you in any white-collar matter. And that's the end of my presentation, unless anybody has any questions.